Good afternoon, everyone, and welcome to the webinar, The Legal Landscape of Interstate Compacts, sponsored here at the Council of State Governments. My name is Coleman Elridge. I'm the Director of the National Center for Interstate Compacts, and I'm pleased to be joined today by Rick Masters, the guru of interstate compacts, who will share a little analysis on the legal landscape of interstate compacts as it's ever-changing throughout the nation. A couple of housekeeping notes before we get started. Please feel free to submit questions in the question box of your go-to webinar panel. This session will be recorded, and all registered attendees will receive a copy of the webinar and the PowerPoint presentation in the next few days. As I said, and without further ado, I want to turn it over to Rick Masters, who is the special counsel for the National Center for Interstate Compacts. And literally, I do not think, Rick, that there is a single compact that's going on right now that you've not had at least a fingerprint, if not a thumbprint or a footprint in. And so just thank you for your time, and thank you for joining us today to walk through what is an immensely changing landscape of legalities in terms of the interstate compact mechanism. So, Rick Masters.
All right, thank you, Coleman. And I hope all of you are bracing yourselves for a stimulating journey through the landscape of interstate compacts. It's one of those topics where not many people are interested, but when you need to know something about them, it's helpful to have some resources to turn to. And as we refer to this as the legal landscape of interstate compacts, we want to point your attention to one of those resources, which CSG had no small part in preparing. 3 of the 4 authors, well, actually all 4 of the authors have had relationships with the Council of State Governments in one way or another over the last 30 years, including yours truly. And I would commend the book that is on your screen to the right as the last in the series of evolutions regarding at least the publications concerning interstate compacts. CSG, as you can see on the left side of the screen, was involved as early as 1925 in producing information concerning interstate compacts from that year through the date of publication by Frederick Zimmerman and Mitch Wendell, who also were at that time affiliated with the Council of State Governments. Actually, I think that book was originally published in the 60s, and then again in the 1970s, that book, The Law and Use of Interstate Compacts by Mr. Zimmerman and Mr. Wendell, was updated. And that was the last time the subject had been visited in any comprehensive way in the 1970s until the first edition of the book that you see to your far right, which was at first known as The Evolving Use and Changing Role of Interstate Compacts, a practitioner's guide. And we've now published a second edition that the friends at the American Bar Association have put on the shelves or online or wherever the case may be for your benefit. It can be ordered from the ABA either at their website or at any of the seminars where this book might be available, that in some cases has been provided access through CSG seminars of various types, including the one we had in Williamsburg at the end of the year last year. So feel free to let us know if you need guidance in finding more about how to avail yourselves of this resource. But I will say also that because this is a resource that is available to you, including case law and citations to other legal authorities, we have not chosen to make this a lawyer's continuing education course, so I don't have a long list of case sites to provide you with today, but all of the cases that I'm going to mention are cited in the book, The Evolving Law and Use of Interstate Compacts. So if you need to get access to those, you can do so through that book. So let's talk about this subject in more detail, and since we don't have a lot of time, we will move with expediency through this, hopefully not at the expense of quality, but we certainly will provide follow-up to this through questions today and after the fact if you have any. We're going to look at the legal landscape in terms of both federal and state law, the courts, and interstate compact law itself, which has developed to the point that we've written a book about it. There's over 1,000 footnotes in our book that ABA has published about this subject, and you will find that it is an emerging area that continues to produce case after case, which we call attention to when we think that it would be beneficial for those who are involved in this field of study, of research, and of government. Let's go to the next slide. With regard to administrative regulations, which is a frequent source of questions regarding interstate compacts, it is important to understand that these compacts that create regulatory bodies or agencies are not automatically subject to the Federal Administrative Procedures Act, or for that matter, the various state administrative procedures acts. That's because in most cases, the compacts are not defined as federal agencies, and although in some cases compact governing bodies are joint agencies of the states, they are not the creature of one particular state to the exclusion of all the others. They're a joint enterprise and a joint governing activity of the states. And so neither the federal APA or state APA applies, and that makes it incumbent upon those who draft compacts to be sure that they have determined where the source of procedure should come from for any rules that a compact is empowered to make. And that could be referring to the Federal Administrative Procedures Act, and there are examples of compacts that use that as a basis for rulemaking. One that comes to mind is the Interstate Compact for Adult Offender Supervision, or other compacts which rely upon the Uniform State Administrative Procedures Act, which the Uniform Law Commission updates from time to time. And there are a number of the healthcare compacts that are making their way through the legislatures concerning health professional licensure, whether it be nurses or doctors or physical therapists and other health professionals. Many of those compacts rely upon the State Administrative Procedures Act for the source of their administrative procedures. Let's talk to the next slide here. With regard to legal controversies that may arise in the implementation, administration, or enforcement of interstate compacts, whether or not a compact agency or states which are members of an interstate compact and may have a dispute among one another will resort to federal or state court is dependent, as are most issues revolving around interstate compact, on whether or not the compact itself has received congressional consent or is simply an enactment of the states that does not require federal consent for its authority. And you may remember from other presentations that we have made through the years that the critical issue on whether or not congressional consent is granted is whether or not the function of the compact interferes with some enumerated power which is delegated to the federal government under the federal Constitution. And if the compact will conflict with or tread upon those enumerated powers, then congressional consent is required. However, the Supreme Court has made clear in a number of case decisions over the last 200 years that many issues that states manage through interstate compacts can be done without the need for congressional consent in those areas where states have traditionally had authority to regulate and decide to use an interstate compact mechanism to do that governing on an interstate basis typically do not require congressional consent. And so that will determine in many cases whether or not federal or state courts will be involved. It's also important to know that where there are disputes between the states, since they are co-sovereigns within our federal system, federal court is, in many cases, the court into which those sorts of disputes will be brought, and where states are called upon to enforce compact provisions against other member states that are not complying with the compact provisions, typically that will be done in federal court. Most compacts do include venue provisions which specify into which court those sorts of disputes will be brought, and in most cases, for disputes among the states, federal court will be selected, where the regulations that the compact is delegated with the authority to promulgate, if any, many of those regulations are enforced and applied at the state court level. Examples would be those compacts for the management of offenders, such as the Interstate Compact for Adult Offenders, and placement of children, such as the ICPC, or supervision of juvenile offenders, such as the Interstate Compact for Juveniles. Let's go to the next slide. As this slide prompts us to consider, courts typically don't assume or afford treatment to a government entity created by a compact as a federal agency. There are cases in which compacts are treated as state agencies. And again, we must look to the compact to determine what the intention of the drafters is in this regard. And it is almost always the case that compacts, particularly those that are charged with some type of regulatory authority, will define the agency that will govern them. Now, this is a commonly misunderstood aspect of interstate compacts. Compact statutes, because they are creatures of the legislatures, can create governmental bodies which have the authority that is delegated to them by the states which enact the compact. And in creating that governmental structure, it is authorized for state legislatures to create a joint agency of the states that have enacted the compact. That is not the same as a private organization. It is not incorporated like a not-for-profit organization. It is a separate and distinct legal entity, just like a state or federal agency, except this one has interstate authority that is granted to it on a multi-state basis by the compact statutes that enact the compact. And the authority to do this, to create these types of entities, and to empower them with administrative authority goes back at least as far as the 1950s. And there's a case by the name of West Virginia Ex Rel Dyer versus Sims, which is one of the few cases I'm going to cite today. It's at 341 U.S. page 22, a 1951 case that the court, the Supreme Court of the United States, clarified that it is an axiom of modern government for a state legislature to create an interstate entity such as the compact agency and to empower it to make rules. That subject was revisited as recently as 2010 in another Supreme Court decision by the U.S. Supreme Court in Alabama versus North Carolina, in which that same principle was upheld. Which law will a compact apply? As indicated on the slide, again, it's a question that depends upon what aspect of compact enforcement that we are referring to. With regard to rules or regulations, which compacts administer when they are exercising state functions, like transferring offenders or placing children, the law that would generally apply for enforcement of the compact among the states would be federal. The application and implementation of the rules of such compacts that are applying to state transactions where things like supervision of offenders or placement of children is being transferred would be state law, and state courts would have the authority and exercise that authority to interpret and apply those rules. Another important value and point of understanding, in fact, a fundamental precept, I guess I would call it, of interstate compacts, is that contract law applies to the application of compacts and their interpretation. The easy answer as to why that is the case is to remember that compacts are, in fact, contract agreements. The only difference between a compact and other types of contracts between private parties is that those compacts, as contractual instruments, bind together state governments rather than individuals or private entities. And so contract law principles apply when a court is interpreting a compact, whether it be the Supreme Court, lower federal courts, or state courts. Compacts are contracts, and so all of those traditional factors that contract lawyers would argue about come into play in many cases where compact provisions are being interpreted, applied, and enforced. Things such as whether or not the states have agreed upon the intent and the purposes of the compact in a way that all of the agreements identify similar provisions and have uniform application throughout all the member states. This is why it's important that compact statutes, when they're being debated, introduced, and enacted by the states, have to be substantially similar provisions. And this is why, unlike other types of statutes, compacts generally can't be substantially amended so that they are significantly different in one state than other states which have adopted the compact. Why is that? Because it's a contract. And if the provisions of the contract are not the same among all of the states, then the goal of uniformity cannot be achieved. Courts certainly consider contract principles in terms of the day-to-day administration, application, and enforcement of compacts, but on a broader scale, from the 50,000-foot view, courts also look at the primary purpose and the political policy that is being served by an interstate compact, and that is, it is a method, as we've said time and again, and many of you, I'm sure, have heard us say this, and if there's one thing that I would emphasize once again over anything else that you hear today, the purpose of a compact is to allow the states to achieve uniformity without the need for federal intervention. This is why they are such an attractive tool and continue to be an attractive tool to state legislators and legislatures as a method of managing interstate transactions among the states. The states can continue to control the legal authority over the compact transactions which are served by that set of statutes, and it is not necessary for the federal government to preempt the states and intervene in their affairs. As has been said, it is not unusual at all for a compact to engage in rulemaking. It is a common practice which has been generally accepted and understood by courts considering the subject, and like other types of administrative rulemaking, compact agencies are generally given deference by the courts with respect to rules that are promulgated by a compact agency. Like other administrative agencies, the reason for their existence is the specialized nature of the particular set of regulatory transactions that the compact is performing. And so courts will generally defer to that authority as long as it is clear that the actions of the compact agency are within the scope of the authority granted to the compact by the legislatures that have enacted the compact statute, and that those actions don't violate the Constitution of the states or the federal Constitution. Having talked about some of the nuts and bolts, if you will, of the law of interstate compacts and the applicable principles, let's look at some of the emerging issues. We've got a number of things that could be mentioned here as a list of politically charged subjects, I guess dependent to some extent on your point of view, but I think all of us can agree that the controversy concerning electoral votes versus popular votes continues to be a topic that is hotly debated among our citizens. And you hear calls for things like going away with the Electoral College, or endorsements of the Electoral College as being the most prescient thing the Founding Fathers ever did. Whichever side you're on, or somewhere in between, there's an issue here that there's been at least one compact that has been developed to reflect the fact that this is a highly charged issue. And whatever your position on this may be, it's important to understand that compacts reflect the popular culture in terms of hotly debated topics. And so the popular vote compact is one example of a politically charged subject, which would essentially limit the impact of the Electoral College in a way that would prefer the popular vote over the Electoral College. And whether one thinks that is good or bad is going to shape your view of whether that compact should be adopted. And I believe to date there are approximately 8 or 10 states that have enacted it. I don't know if that will be something that other states will become involved in, but it's an important subject to know about in terms of one of the hot topics. Similarly, there are compacts that are calling upon the federal government to balance the budget, and would accomplish that through the device of an interstate compact. There are also calls that have gone out for compacts involving health insurance portability across state lines. In fact, the Affordable Care Act, which is likely to be subject to some legislative changes or repeals or all of the above over the next months or years, has been the subject of continuing discussions regarding healthcare exchanges and doing business across state lines by health insurers. And there may be discussions that will continue to take place concerning whether or not healthcare insurers should be doing business across state lines by virtue of an interstate compact. We also have a series of healthcare providers who are interested in license portability for health professionals. Look for other developments in this regard. Keep in mind that compacts, like other political governing devices, can be employed rightly or wrongly to do a wide variety of things, and it's always important to understand, like any other legislation, what the purpose and goal of a particular compact will be and what your opinion of it is. There are a few hot topics that we want to discuss here with respect to interstate compacts. Probably the most significant series of cases is exemplified by this case that is on the screen, Gillette versus the Franchise Tax Board, which is a California Supreme Court decision of recent vintage. The case involves the multi-state tax compact, to which many states were parties and some still are parties. Over the years that compact has been in effect, there have been a number of state variations in the language of the compact, in which some states have made unilateral changes to the compact. There was a challenge to that practice in the state of California, in which taxpayers filed a challenge regarding the change of a tax rate that would have benefited the challengers in a way that was changed by the legislature in conflict with the provisions of the multi-state tax compact. They brought a legal challenge on the theory that because compacts are contracts, the legislature cannot violate a particular provision of a compact by enacting conflicting legislation, and that to do so would violate the contract clause of the Constitution, requiring that states refrain from engaging in any activity that would impair the obligations of contracts. And there are provisions not only in the federal Constitution, but in most, if not all, state constitutions protecting contractual relationships in that way, including interstate compacts. The California Supreme Court held that because there had been state acquiescence by the member states that were members of that compact to these unilateral changes that had been made over the years, that the agreement could not properly be viewed as a binding contractual relationship. And while the California Supreme Court said that this case was, to use a Latin phrase, sui generis, which means one of a kind and limited to its own facts, the fact is that because a Supreme Court of a state has issued an opinion that seems to be, at least on its face, at odds with one of those fundamental compact precepts that compacts are contracts, it's one that could create potential impediments and threats in the future from those who might wish to, I guess, misuse this holding to extend it beyond the facts of that particular case. So I think it's an important topic. It's our view that we ought to take the Supreme Court of California at its word, and hopefully that this will be an aberration and a case that is limited to its own peculiar set of facts. We also, before we leave, and we are nearing the end, I think we have been successful at expediently getting through our discussion today, but we want to call your attention to some news that we think is important with regard to the Interstate Compact Summit, which CSG has been convening for some time, although not very frequently. But beginning in December of this past year, December 2016, there was a tremendous gathering in Williamsburg, Virginia at the conclusion of the CSG annual meeting, at which we had a large number of participants who wanted to make this a more regular event. So we are going to be holding an annual Compact Summit beginning again in 2017 in conjunction with the CSG annual meeting. Coleman, you may have some comments about that.
Well, as Rick said, we really relaunched this last year in Colonial Williamsburg, and it was a great success. And when you bring together this community, there was a sense of we should get together more often, and so we're going to continue that in Las Vegas this winter. It will be held in conjunction with the CSG annual meeting as well, and we'll have more to come on that, but we just wanted everyone to put it on their radars because, as we said before, this presentation was one that was actually in a larger scale was presented in Williamsburg, and it was one of the most demanded sessions. And so we're going to continue to build out the offerings of that of the next summit. It will include more about the legal landscape. It will include issues of governance and other issues concerning the interstate compact mechanism and community. But we simply just wanted to make sure that was on your radar. It looks like we have a question, and so we're going to get to that question. And then, Rick, I want to go back to something that you were talking about in terms of the ever-changing landscape as healthcare compacts are concerned.
Right.
So, but it looks like we have a question from a legislative drafter who says, who asked a kind of a three-part question. What is the best way to distinguish a compact from a model law? So that's the first question. The second part of that is, in addition to being enacted as a state law, a compact is an agreement between the states. Can the legislation itself act as an agreement, or must there be a separate agreement, typically between the executive, I guess the three branches? And the third question is, because a compact is an agreement between the states, aren't the compacting states the only parties who can enforce the compact? Or can the compact grant standing to individuals to enforce its terms? Those are all three great questions, Rick. We'll turn it over to you to answer in whatever order you'd like to.
I'll avoid the technique that many of our presidents, both current and former, have used to only pick one of the multi-part questions to answer. I'll try to answer all three parts to the extent I can. You are correct that a compact is distinctly different from a model law. Sometimes model laws, which many times are the product of the Uniform Law Commission, which produces a variety of these model enactments that include such things as the Uniform Commercial Code and various reciprocal child support enforcement statutes and so on. The primary difference is that the model law is not contractual. The states do not enter into any kind of contractual promise to each other that they will adopt uniform provisions in each state that are binding collectively among them. That's why in many cases you will see uniform laws or model laws that have been modified or changed throughout the states. Many times they're very similar in most respects, but states are not obligated to enact identical language, and you do find departures from state to state. For example, I recall in law school when we were studying Uniform Commercial Code provisions, there was always an exception for states like Louisiana that for some reason had not adopted large sections of the UCC. I don't know if that's changed yet or not, but I think that's a good example. So that would be the most important distinction between the two. As to agreements between states and how that works, the agreements that you refer to as being other than legislation itself, or separate agreements between the branches of government, such as the executive branches, would be more limited agreements. The compact, in order to qualify, needs to be an enactment that has been adopted by the legislature so that the state is truly a party to the agreement and not simply one or more agencies of the state that may have authority to enter into a governmental agreement, which is something less than a compact. So I would say the governmental agreement that you're referring to between, say, executive branch officials or governors are usually those that are for a very narrow purpose and are much less binding than a compact would be in terms of the state adopting that as its contractual promise. Finally, you are correct that because the compact is a legislative enactment which constitutes an agreement between the states, that typically the states are the parties that would enforce the agreement. However, the language of the compact may afford third parties rights either as third-party beneficiaries or intended beneficiaries of the provisions of the compact. And the Supreme Court has told us that for certain purposes, such as liability under the Civil Rights Act, for example, the language of the compact must specifically have language that indicates an intent to benefit these third parties or other parties that have some rights that are created under the compact. In the absence of specific language clearly delineating that that is the intent, in many cases courts have concluded that the states themselves are the parties that are solely able to enforce the compact provision.
Great. Rick, I wanted to, and that is probably, we actually have another question from Alice regarding the recent erosion of the state action antitrust immunity defense in the North Carolina Dental Board case. Are there implications for compacts for professional regulation which vest rulemaking authority with a commission composed of administrators from the various member states?
No more so than the holding of the case itself, which in my humble opinion is primarily directed at the notion that the purpose of professional licensure is to protect the public. And if the regulation, whether it's by virtue of a state board individually in a particular state or collectively by states that are, say, parties to a compact regulating professional licensure, if the regulation is for the protection of the public, I think it passes muster under the North Carolina Dental Board case. If it's more in the nature of an economic protection for a particular industry, then like the North Carolina Dental Board situation with teeth whitening, it's probably going to subject those boards or collectively a compact agency, for example, to some type of antitrust immunity.
Rick, I want to follow up on that, and that actually, thank you, Alice, is a great segue into the issue of the ever-growing amount of healthcare-related compacts. That we see it across the board. We have medical licensure, which of course is already making its way into the commission status, physical therapy compact, nurse licensure, EMS, psychologists. The list is ever growing and ever changing. But to Alice's point, are you seeing any as more of these compacts pass and they're standing up commissions? Do you foresee any other legal complications, legal challenges, legal issues as compacts are really being used to broaden the utilization or the practice of healthcare and the consumption then of healthcare across state lines?
Well, I think that the notion that states are trying to maintain their supremacy over professional regulation is an important part of the process, and I personally think that's what the Founding Fathers intended in our Constitution, that states should continue to manage those activities that are closest to its people and that are potentially endangering citizens if not adequately protected. And I think that's why professional licensure has largely been a function of the states. The problem that has developed is that with the need for increasing accessibility to care and insufficient numbers in many health professions of qualified licensed professionals, coupled with the advent of technology and telehealth, where diagnosis and treatment can be done virtually over the internet, over the phone, over our various electronic devices, the need for changing the way in which we regulate has become apparent. Like someone said, we're using our grandparents' laws to regulate our grandchildren's technology, and there's a disconnect which needs to be resolved. And I think compacts can supply part of that gap, and hopefully in a way that preserves state authority over health professional regulation. Because if the states can't make this work and we can facilitate license portability and practice across state lines, whether on an electronic basis or not, the federal government, I firmly believe, and there's evidence in the form of legislation that's been introduced at various times on Capitol Hill, that the federal government will insert itself into this situation, if for no other reason, because they will argue that the public safety needs to be protected, and if the states can't do it, the federal government will attempt to do it.
Going back to, you mentioned the National Popular Vote Compact, which is making its way. I think it's passed in 10 states, including 10 states and the District of Columbia. They've got about 165 electoral votes that make up the states that have ratified it so far, which equals out to be about 30.7% of the Electoral College, 61% of the votes needed for the compact to be enforced. Couple of questions. One, will that compact, in your opinion, need to have congressional consent? And two, whether it does or whether it does not, what then are some of the possible legal challenges if they do in fact hit this threshold?
Well, I think that question is well worth asking, and I know there is debate about that subject. I know some of the proponents of the Popular Vote Compact have opined one way or the other on whether congressional consent is necessary. I'll simply return to my understanding of what the Supreme Court has taught us about when that's required. And if the compact could arguably interfere with or conflict with some enumerated federal power, then congressional consent is required and certainly should be considered if you want to avoid a constitutional challenge for not having consent. Since this implicates the portion of the Constitution devoted to the Electoral College, which is a function of the Constitution, I have a hard time understanding how it wouldn't potentially interfere with the provisions of the Constitution, because that's the intention. So yes, I think consent is probably required, and at the very least would be a good idea in order to avoid what I suspect will be a constitutional challenge to that compact if it reaches critical mass and actually becomes implemented.
Great. Well, Rick, thank you so much for being here with us today. Thank you for your insights. Again, if you have any questions, please feel free to contact Rick or myself. This, as we noted before, this webinar is being recorded, and so in the next few days, we hope to get a copy of this presentation as well as the accompanying PowerPoint to all registered attendees. We want to thank Shante Hopkins from the communications outfit here at CSG for getting all of this together. If you heard us well, if you were able to look at and see everything on the screen, that was all the magic of Shante. So we are grateful for her and to her. And again, if you have any other questions, please feel free to contact us at the National Center for Interstate Compacts. Thank you again for your attendance, and